Hello, I'm attorney Paul Whalen from Afford Law. At Afford Law, we practice criminal and family law throughout Massachusetts. All of our fees are based on your income, so that means the less you earn, the less you have to pay for our services. Today, I want to take a moment to discuss with you a couple of issues involving child support and visitation. Visitation is now called parenting time. Sometimes the question comes up. We get someone comes into the office and says, "My ex isn't paying child support. I don't want to let him or her see our child. Can I do that?" And basically, the answer to that question is no. You cannot. You cannot prevent your the other parent from having time with your child or children based on the fact that he or she is not paying child support, if they're behind in their child support. And the reason for that is that it's in the best interest of the child for the child to have a bond with the other parent. Everything in the family courts involving children are based on the child's best interest. So it's considered to be in the child's best interest to be able to spend time with the other parent and develop a relationship with them. If you deny visitation or parenting time with that child, the child won't have a chance to get to know that parent, to form that bond, and to be able to have a relationship going forward. So the other parents' rights are not based on their ability or their successfully paying their child support. So you cannot, on your own, refuse to let another parent see your children. Alternatively, if, for instance, the other parent isn't paying child support, let's take a look at it the other way. If there's a visitation issue, and sometimes people come into the office and they say, "I'm not getting visiting time with my child. I want to stop paying child support. Can I do that?" Well, the answer to that question is also no. You cannot do that because the child support is for the benefit of your child. It's not for the benefit of the other parent. So by cutting off that support to the child, certainly that's not in the child's best interest. The support is needed to help raise the child. So those are two separate issues. One of them is not dependent upon the other. If you're having issues with in either of these arenas, either child support or parenting visitation time, then you have to go to court. If someone is not fulfilling their obligations under a court order, the proper step to take is to bring that person into court on a contempt action. First, try to work it out amongst yourselves. That's always the best idea, least expensive, and oftentimes the most efficient. But if the person refuses to live up to their end of the bargain, to fulfill the court's order, then you have to take it before a judge on a contempt proceeding. You cannot act unilaterally to either stop child support or stop the other parent from having parenting time with your children, because in either case, it's not in the best interest of the kids, and ultimately they are the ones that would suffer from either of those two things happening. The court has a lot of things that they can do to try to kind of leverage the other person to either start paying child support to catch up with it, or to allow the person to have visitation with their children. Another thing too is in child support cases, if you have lost your job, for instance, or if you suffer from a significant loss of income, just because that happens doesn't mean that your obligations to the child are any less, your financial obligations are any less. You need to go to court at that point and say that there's been a change in circumstances and you're trying to modify the child support. So let's say you're originally, when the child support order went into effect, you were making, I don't know, let's just say $100,000, and then you lost your job or you got cut back on the hours, and now you're making $50,000 a year. So that's a significant change in income. Obviously, you can't all of a sudden just say, "I'm going to cut that child support in half because I'm now making half of what I used to make." It doesn't work that way. You have to go back to court and ask the court for a modification on the child support. There will be a child support formula. The guidelines will be used, and you'll get a new child support order if the judge feels that there has been a significant change in circumstances and that it's in the child's best interest. So basically, the rule here and the lesson to be learned is that you basically can't do anything on your own as far as changing anything in your agreements or in the order with the court. You must go before a judge and have the judge make a different decision, enter a different order based on new circumstances. As I say, at Afford Law, we do practice criminal and family law throughout Massachusetts. Our fees are all based on your income, so the less you make, the less you have to pay for our services. We're trying to give voice in the courtroom to the hardworking people of Massachusetts. Feel free to visit us at affordlaw.org and feel free to book a free virtual appointment with me. I'd be happy to answer any questions you might have on any criminal law or family law matters in Massachusetts. Because at Afford Law, we're making justice affordable.